3102. Subject matter. This article applies to negotiable instruments. It does not apply to money, to payment orders governed by Article 4A, or to securities governed by Article 8B. If there is conflict between this article and Article 4 or 9, Articles 4 and 9 govern. C. Regulations of the Board of Governors of the Federal Reserve System and operating circulars of the Federal Reserve Bank supersede any inconsistent provision of this article to the extent of the inconsistency. 310.3. Definitions. In this article, one acceptor means a draftee who has accepted a draft. 2. Consumer account means an account established by an individual primarily for personal, family, or household purposes. 3. Consumer transaction means a transaction in which an individual incurs an obligation primarily for personal, family, or household purposes. 4. Draftee means a person ordered in a draft to make payment. 5. Drawer means a person who signs or is identified in a draft as a person ordering payment. 6. Reserve. 7. Maker means a person who signs or is identified in a note as a person undertaking to pay. 8. Order means a written instruction to pay money signed by the person giving the instruction. The instruction may be addressed to any person, including the person giving the instruction, or to one or more persons jointly or in the alternative, but not in succession. An authorization to pay is not an order unless the person authorized to pay is also instructed to pay. 9. Ordinary care. In the case of a person engaged in business means observance of reasonable commercial standards prevailing in the area in which the person is located with respect to the business in which the person is engaged. In the case of a bank that takes an instrument for processing for collection or payment by automated means, reasonable commercial standards do not require the bank to examine the instrument if the failure to examine does not violate the bank's prescribed procedures and the bank's procedures do not vary unreasonably from general banking usage not disapproved by this article or Article 4. 10. Party means a party to an instrument. 11. Principal obligor, with respect to an instrument, means the accommodated party or any other party to the instrument against whom a secondary obligor has recourse under this article. 12. Promise means a written undertaking to pay money signed by the person undertaking to pay. An acknowledgement of an obligation by the obligor is not a promise unless the obligor also undertakes to pay the obligation. 13. Proof with respect to a fact means to meet the burden of establishing the fact. Section 121b8. 14. Reserve. 15. Remiter means a person who purchases an instrument from its issuer if the instrument is payable to an identified person other than the purchaser. 16. Remotely created consumer item means an item drawn on a consumer account, which is not created by the payer bank and does not bear a handwritten signature purporting to be the signature of the drawer. 17. Secondary obligor, with respect to an instrument, means an endorser or an accommodation party, be a drawer having the obligation described in Section 3414D, or C any other party to the instrument that has recourse against another party to the instrument pursuant to Section 3116B. B. Other definitions applying to this article and the sections in which they appear are: acceptance, Section 3409, accommodated party, Section 3419, accommodation party, Section 3419, account, Section 410.4, alteration, Section 3407, anomalous endorsement, Section 3205, blank endorsement, Section 3205, cashier's check, Section 3104, certificate of deposit, Section 3104, certified check, Section 3409, check, Section 3104, consideration, Section 3303, draft, Section 3104, holder in due course, Section 3302, incomplete instruments, Section 3115, endorsement, Section 3204, endorser, Section 3204, instruments, Section 3104, issue, Section 3105, issuer, Section 3105, negotiable instruments, Section 3104, negotiation, Section 3201, notes, Section 3104, payable at a definite time, Section 3108, payable on demand, Section 3108, payable to bearer, Section 3109, payable to order, Section 3109, payment, Section 3602, person entitled to enforce, Section 3301, presentment, Section 3501 Requisition Section 3207 Special Endorsement Section 3205 Teller's Check Section 3104 Transfer of Instrument Section 323 Traveler's Check Section 3104 Value Section 3303 See the following definitions and other articles apply to this article. Banking Day Section 410.4 Clearinghouse Section 410.4 Collecting Bank Section 4105 Depository Bank Section 4105 Documentary Draft Section 410.4 Intermediary Bank Section 4105 Item Section 410.4 Payer Bank Section 4105 Suspends Payment Section 410.4 3104 Negotiable Instrument except as provided in subsections C and D. Negotiable instrument means an unconditional promise or order to pay a fixed amount of money, with or without interest or other charges described in the promise or order, if it 1. is payable to bearer or to order at the time it is issued or first comes into possession of a holder, 2. is payable on demand or at a definite time, and 3. does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money. But the promise or order may contain an undertaking or power to give, maintain, or protect collateral to secure payment. Roman 2. An authorization or power to the holder to confess judgment or realize on or dispose of collateral. Or Roman 3. A waiver of the benefit of any law intended for the advantage or protection of an obligor. B. Instrument means a negotiable instrument. C. An order that meets all of the requirements of subsection A, except paragraph 1. and otherwise falls within the definition of check in subsection F is a negotiable instrument and a check. D. A promise or order other than a check is not an instrument if, at the time it is issued or first comes into possession of a holder, it contains a conspicuous statement, however expressed, to the effect that the promise or order is not negotiable or is not an instrument governed by this article. E. An instrument is a note if it is a promise and is a draft if it is an order. If an instrument falls within the definition of both note and draft, a person entitled to enforce the instrument may treat it as either. F. Check means a draft, other than a documentary draft, payable on demand and drawn on a bank or Roman 2 a cashier's check or teller's check. An instrument may be a check even though it is described on its face by another term, such as money order. G. Cashier's check means a draft with respect to which the drawer and drawee are the same bank or branches of the same bank. H. Teller's check means a draft drawn by a bank on another bank or Roman 2 payable at or through a bank. I. Traveler's check means an instrument that I is payable on demand. Roman 2 is drawn on or payable at or through a bank. Roman 3 is designated by the term traveler's check or by a substantially similar term, and Roman 4 requires, as a condition to payment, a countersignature by a person whose specimen signature appears on the instrument. J. Certificate of deposit means an instrument containing an acknowledgement by a bank that a sum of money has been received by the bank and a promise by the bank to repay the sum of money. A certificate of deposit is a note of the bank. 3105. Issue of instrument. Issue means the first delivery of an instrument by the maker or drawer, whether to a holder or non-holder, for the purpose of giving rights on the instrument to any person. B. An unissued instrument or an unissued incomplete instrument that is completed is binding on the maker or drawer, but non-issuance is a defense. An instrument that is conditionally issued or is issued for a special purpose is binding on the maker or drawer, but failure of the condition or special purpose to be fulfilled is a defense. C. Issuer applies to issued and unissued instruments and means a maker or drawer of an instrument. 3106. Unconditional promise or order. Except as provided in this section, for the purposes of section 3104, a promise or order is unconditional unless it states an express condition to payment. Roman 2 that the promise or order is subject to or governed by another record, or Roman 3 that rights or obligations with respect to the promise or order are stated in another record. A reference to another record does not of itself make the promise or order conditional. B. A promise or order is not made conditional by a reference to another record for a statement of rights with respect to collateral, prepayment, or acceleration, or Roman 2 because payment is limited to resort to a particular fund or source. C. If a promise or order requires, as a condition to payment, a countersignature by a person whose specimen's signature appears on the promise or order, the condition does not make the promise or order conditional for the purposes of Section 3104A. If the person whose specimen's signature appears on an instrument fails to countersign the instrument, the failure to countersign is a defense to the obligation of the issuer, but the failure does not prevent a transferee of the instrument from becoming a holder of the instrument. D. If a promise or order at the time it is issued or first comes into possession of a holder contains a statement required by applicable statutory or administrative law to the effect that the rights of a holder or transferee are subject to claims or defenses that the issuer could assert against the original pay, the promise or order is not thereby made conditional for the purposes of Section 3104. But if the promise or order is an instrument, there cannot be a holder in due course of the instrument. 3107. Instrument payable in foreign money, unless the instrument otherwise provides. An instrument that states the amount payable in foreign money may be paid in the foreign money or in an equivalent amount in dollars calculated by using the current bank offer spot rate at the place of payment for the purchase of dollars on the day on which the instrument is paid. 3108. Payable on demand or at definite time. A promise or order is payable on demand if it states that it is payable on demand or at sight, or otherwise indicates that it is payable at the will of the holder, or Roman 2 does not state any time of payment. B. A promise or order is payable at a definite time if it is payable on a lapse of a definite period of time after sight or acceptance, or at a fixed date or dates, or at a time or times readily ascertainable at the time the promise or order is issued. Subject to rights of prepayment, Roman 2 acceleration, Roman 3 extension at the option of the holder, or Roman 4 extension to a further definite time at the option of the maker or acceptor, or automatically upon or after a specified act or event. C. If an instrument, payable at a fixed date, is also payable upon demand made before the fixed date, the instrument is payable on demand until the fixed date, and, if demand for payment is not made before that date, becomes payable at a definite time on the fixed date. 3109. Payable to bearer or to order. A promise or order is payable to bearer if it 1 states that it is payable to bearer or to the order of bearer, or otherwise indicates that the person in possession of the promise or order is entitled to payment. 2. Does not state a pay, or 3. States that it is payable to or to the order of cash, or otherwise indicates that it is not payable to an identified person. B. A promise or order that is not payable to bearer is payable to order if it is payable to the order of an identified person, or Roman 2 to an identified person or order. A promise or order that is payable to order is payable to the identified person. C. An instrument payable to bearer may become payable to an identified person if it is specially endorsed pursuant to Section 3205A. An instrument payable to an identified person may become payable to bearer if it is endorsed in blank pursuant to Section 3205B. 3110. Identification of person to whom instrument is payable. The person to whom an instrument is initially payable is determined by the intent of the person, whether or not authorized, signing as, or in the name or behalf of, the issuer of the instrument. The instrument is payable to the person intended by the signer even if that person is identified in the instrument by a name or other identification that is not that of the intended person. If more than one person signs in the name or behalf of the issuer of an instrument and all the signers do not intend the same person is paid, the instrument is payable to any person intended by one or more of the signers. B. If the signature of the issuer of an instrument is made by automated means, such as a check writing machine, the pay of the instrument is determined by the intent of the person who supplied the name or identification of the pay, whether or not authorized to do so. C. A person to whom an instrument is payable may be identified in any way, including by a name, identifying number, office, or account number. For the purpose of determining the holder of an instrument, the following rules apply. 1. If an instrument is payable to an account and the account is identified only by number, the instrument is payable to the person to whom the account is payable. If an instrument is payable to an account identified by number and by the name of a person, the instrument is payable to the named person, whether or not that person is the owner of the account identified by number. 2. If an instrument is payable to I. The trust, an estate, or a person described as trustee or representative of a trust or estate, the instrument is payable to the trustee, the representative, or a successor of either, whether or not the beneficiary or estate is also named. Roman 2. A person described as agent or similar representative of a named or identified person, the instrument is payable to the represented person, the representative, or a successor of the representative. Roman 3. A fund or organization that is not a legal entity, the instrument is payable to a representative of the members of the fund or organization. Or Roman 4. An office or to a person described as holding an office, the instrument is payable to the named person, the incumbent of the office, or a successor to the incumbent. D. If an instrument is payable to two or more persons alternatively, it is payable to any of them and may be negotiated, discharged, or enforced by any or all of them in possession of the instrument. If an instrument is payable to two or more persons not alternatively, it is payable to all of them and may be negotiated, discharged, or enforced only by all of them. If an instrument payable to two or more persons is ambiguous as to whether it is payable to the persons alternatively, the instrument is payable to the persons alternatively. 311. Place of payment. Except as otherwise provided for items in Article 4, an instrument is payable at the place of payment stated in the instrument. If no place of payment is stated, an instrument is payable at the address of the drawer or maker stated in the instrument. If no address is stated, the place of payment is the place of business of the drawer or maker. If a drawer or maker has more than one place of business, the place of payment is any place of business of the drawer or maker chosen by the person entitled to enforce the instrument. If the drawer or maker has no place of business, the place of payment is the residence of the drawer or maker. 312. Interest. Unless otherwise provided in the instrument, an instrument is not payable with interest. In Roman 2, interest on an interest-bearing instrument is payable from the date of the instrument. B. Interest may be stated in an instrument as a fixed or variable amount of money, or it may be expressed as a fixed or variable rate or rates. The amount or rate of interest may be stated or described in the instrument in any manner and may require reference to information not contained in the instrument. If an instrument provides for interest, but the amount of interest payable cannot be ascertained from the description, interest is payable at the judgment rate in effect at the place of payment of the instrument and at the time interest first accrues. 311.3. Date of instrument. An instrument may be antedated or postdated. The date stated determines the time of payment if the instrument is payable at a fixed period after date, except as provided in Section 4401C. An instrument payable on demand is not payable before the date of the instrument. B. If an instrument is undated, its date is the date of its issuer. In the case of an unissue instrument, the date it first comes into possession of a holder. 314. Contradictory terms of instrument. If an instrument contains contradictory terms, typewritten terms prevail over printed terms, handwritten terms prevail over both, and words prevail over numbers. 315. Incomplete instrument. Incomplete instrument means a signed writing, whether or not issued by the signer, the contents of which show at the time of signing that it is incomplete, but that the signer intended it to be completed by the addition of words or numbers. B. Subject to subsection C. If an incomplete instrument is an instrument under Section 3104, it may be enforced according to its terms if it is not completed, or according to its terms as augmented by completion. If an incomplete instrument is not an instrument under Section 3104, but after completion, the requirements of Section 3104 are met, the instrument may be enforced according to its terms as augmented by completion. C. If words or numbers are added to an incomplete instrument without authority of the signer, there is an alteration of the incomplete instrument under Section 407. D. The burden of establishing that words or numbers were added to an incomplete instrument without authority of the signer is on the person asserting the lack of authority. 116. Joint and several liability. Contribution. Except as otherwise provided in the instrument, two or more persons who have the same liability on an instrument as makers, drawers, acceptors, endorsers who endorse as joint pays, or anomalous endorsers are jointly and severally liable in the capacity in which they sign. B. Except as provided in Section 3419E or by agreement of the affected parties, a party having joint and several liability who pays the instrument is entitled to receive from any party having the same joint and several liability contribution in accordance with applicable law. 3117. Other agreements affecting instrument, subject to applicable law regarding exclusion of proof of contemporaneous or previous agreements. The obligation of a party to an instrument to pay the instrument may be modified, supplemented, or nullified by a separate agreement of the obligor and a person entitled to enforce the instrument if the instrument is issued or the obligation is incurred in reliance on the agreement or as part of the same transaction giving rise to the agreement. To the extent an obligation is modified, supplemented, or nullified by an agreement under this section, the agreement is a defense to the obligation. 3118. Statute of Limitations. Except as provided in subsection E, an action to enforce the obligation of a party to pay a note payable at a definite time must be commenced within 6 years after the due date or date stated in the note, or, if a due date is accelerated, within 6 years after the accelerated due date. B. Except as provided in subsection D or E, if demand for payment is made to the maker of a note payable on demand, an action to enforce the obligation of a party to pay the note must be commenced within 6 years after the demand. If no demand for payment is made to the maker, an action to enforce the note is barred if neither principal nor interest on the note has been paid for a continuous period of 10 years. C. Except as provided in subsection D, an action to enforce the obligation of a party to an unaccepted draft to pay the draft must be commenced within 3 years after dishonor of the draft or 10 years after the date of the draft, whichever period expires first. D. An action to enforce the obligation of the acceptor of a certified check or the issuer of a teller's check, cashier's check, or traveler's check must be commenced within 3 years after demand for payment is made to the acceptor or issuer, as the case may be. D. An action to enforce the obligation of a party to a certificate of deposit to pay the instrument must be commenced within 6 years after demand for payment is made to the maker, but if the instrument states a due date and the maker is not required to pay before that date, the 6-year period begins when a demand for payment is in effect and the due date has passed. F. An action to enforce the obligation of a party to pay an accepted draft, other than a certified check, must be commenced within 6 years after the due date or date stated in the draft or acceptance if the obligation of the acceptor is payable at a definite time, or Roman II within 6 years after the date of the acceptance if the obligation of the acceptor is payable on demand. G. Unless governed by other law regarding claims for indemnity or contribution, an action I for conversion of an instrument for money had and received, or like action based on conversion, Roman II for breach of warranty, or Roman III to enforce an obligation, duty, or right arising under this article and not governed by this section must be commenced within 3 years after the cause of action accrues. 3119. Notice of right to defend action. In an action for breach of an obligation for which a third person is answerable over pursuant to this article or Article 4, the defendant may give the third person notice of the litigation in a record, and the person notified may then give similar notice to any other person who is answerable over. If the notice states I that the person notified may come in and defend, and Roman II that failure to do so will bind the person notified in an action later brought by the person giving the notice as to any determination of fact common to the two litigations, the person notified is so bound unless after seasonable receipt of the notice the person notified does come in and defend. 3201. Negotiation. Negotiation means a transfer of possession, whether voluntary or involuntary, of an instrument by a person other than the issuer to a person who thereby becomes its holder. B. Except for negotiation by remitter, if an instrument is payable to an identified person, negotiation requires transfer of possession of the instrument and its endorsement by the holder. If an instrument is payable to bearer, It may be negotiated by transfer of possession alone. 3202. Negotiation subject to rescission. Negotiation is effective even if obtained not from an infant, a corporation exceeding its powers, or a person without capacity. Roman 2 by fraud, duress, or mistake, or Roman 3 in breach of duty or as part of an illegal transaction. B. To the extent permitted by other law, negotiation may be rescinded or may be subject to other remedies, but those remedies may not be asserted against a subsequent holder in due course or a person paying the instrument in good faith and without knowledge of facts that are a basis for rescission or other remedy. 323. Transfer of instrument, rights acquired by transfer. An instrument is transferred when it is delivered by a person other than its issuer for the purpose of giving to the person receiving delivery the right to enforce the instrument. B. Transfer of an instrument, whether or not the transfer is a negotiation, vests in the transferee any right of the transferor to enforce the instrument, including any right as a holder in due course. But the transferee cannot acquire rights of a holder in due course by a transfer, directly or indirectly, from a holder in due course if the transferee engaged in fraud or illegality affecting the instrument. C. Unless otherwise agreed, if an instrument is transferred for value and the transferee does not become a holder because of lack of endorsement by the transferor, the transferee has a specifically enforceable right to the unqualified endorsement of the transferor. A negotiation of the instrument does not occur until the endorsement is made. D. If a transferor purports to transfer less than the entire instrument, negotiation of the instrument does not occur. The transferee obtains no rights under this article and has only the rights of a partial assignee. 3204. Endorsement. Endorsement means a signature, other than that of a signer as maker, drawer, or acceptor, that alone or accompanied by other words is made on an instrument for the purpose of negotiating the instrument, Roman 2 restricting payment of the instrument, or Roman 3 incurring endorser's liability on the instrument. But regardless of the intent of the signer, a signature and its accompanying words is an endorsement unless the accompanying words, terms of the instrument, place of the signature, or other circumstances unambiguously indicate that the signature was made for a purpose other than endorsement. For the purpose of determining whether a signature is made on an instrument, a paper affixed to the instrument is a part of the instrument. B. Endorser means a person who makes an endorsement. C. For the purpose of determining whether the transferee of an instrument is a holder, an endorsement that transfers a security interest in the instrument is effective as an unqualified endorsement of the instrument. D. If an instrument is payable to a holder under a name that is not the name of the holder, endorsement may be made by the holder in the name stated in the instrument or in the holder's name or both. But signature in both names may be required by a person paying or taking the instrument for value or collection. 3205. Special endorsement. Blank endorsement. Anomalous endorsement. If an endorsement is made by the holder of an instrument, whether payable to an identified person or payable to bearer, and the endorsement identifies a person to whom it makes the instrument payable, it is a special endorsement. When specially endorsed, an instrument becomes payable to the identified person and may be negotiated only by the endorsement of that person. The principles stated in Section 3110 apply to special endorsements. B. If an endorsement is made by the holder of an instrument and it is not a special endorsement, it is a blank endorsement. When endorsed in blank, an instrument becomes payable to bearer and may be negotiated by transfer of possession alone until specially endorsed. C. The holder may convert a blank endorsement that consists only of a signature into a special endorsement by writing, above the signature of the endorser, words identifying the person to whom the instrument is made payable. D. Anomalous endorsement means an endorsement made by a person who is not the holder of the instrument. An anomalous endorsement does not affect the manner in which the instrument may be negotiated. 3206. Restrictive endorsement. An endorsement limiting payment to a particular person or otherwise prohibiting further transfer or negotiation of the instrument is not effective to prevent further transfer or negotiation of the instrument. B. An endorsement stating a condition to the right of the endorsee to receive payment does not affect the right of the endorsee to enforce the instrument. A person paying the instrument or taking it for value or collection may disregard the condition, and the rights and liabilities of that person are not affected by whether the condition has been fulfilled. C. If an instrument bears an endorsement I described in Section 4201B or Roman 2 in blank or to a particular bank using the words for deposit, for collection, or other words indicating a purpose of having the instrument collected by a bank for the endorser or for a particular account, the following rules apply. 1. A person, other than a bank, who purchases the instrument when so endorsed converts the instrument unless the amount paid for the instrument is received by the endorser or applied consistently with the endorsement. 2. A depository bank that purchases the instrument or takes it for collection when so endorsed converts the instrument unless the amount paid by the bank with respect to the instrument is received by the endorser or applied consistently with the endorsement. 3. A payer bank that is also the depository bank or that takes the instrument for immediate payment over the counter from a person other than a collecting bank converts the instrument unless the proceeds of the instrument are received by the endorser or applied consistently with the endorsement. 4. Except as otherwise provided in paragraph 3, a payer bank or intermediary bank may disregard the endorsement and is not liable if the proceeds of the instrument are not received by the endorser or applied consistently with the endorsement. D. Except for an endorsement covered by subsection C, if an instrument bears an endorsement using words to the effect that payment is to be made to the endorsee as agent, trustee, or other fiduciary for the benefit of the endorser or another person, the following rules apply. 1. Unless there is notice of breach of fiduciary duty as provided in Section 3307, a person who purchases the instrument from the endorsee or takes the instrument from the endorsee for collection or payment may pay the proceeds of payment or the value given for the instrument to the endorsee without regard to whether the endorsee violates a fiduciary duty to the endorser. 2. A subsequent transferee of the instrument or person who pays the instrument is neither given notice nor otherwise affected by the restriction in the endorsement unless the transferee or payer knows that the fiduciary dealt with the instrument or its proceeds in breach of fiduciary duty. D. The presence on an instrument of an endorsement to which this section applies does not prevent a purchaser of the instrument from becoming a holder in due course of the instrument unless the purchaser is a converter under subsection C or has notice or knowledge of breach of fiduciary duty as stated in subsection D. F. In an action to enforce the obligation of a party to pay the instrument, the obligor has a defense if payment would violate an endorsement to which this section applies and the payment is not permitted by this section. 3207. Requisition. Requisition of an instrument occurs if it is transferred to a former holder by negotiation or otherwise. A former holder who requires the instrument may cancel endorsements made after the requirer first became a holder of the instrument. If the cancellation causes the instrument to be payable to the requirer or to bearer, the requirer may negotiate the instrument. An endorser whose endorsement is canceled is discharged, and the discharge is effective against any subsequent holder. 3312. Lost, destroyed, or stolen cashier's check, teller's check, or certified check. In this section, one check means a cashier's check, teller's check, or certified check. 2. Claimant means a person who claims the right to receive the amount of a cashier's check, teller's check, or certified check that was lost, destroyed, or stolen. 3. Declaration of loss means a statement made in a record under penalty of perjury to the effect that either declarer lost possession of a check, Roman 2 the declarer is the drawer or payee of the check in the case of a certified check, or the remitter or payee of the check in the case of a cashier's check or teller's check. Roman 3 the loss of possession was not the result of a transfer by the declarer or a lawful seizure. And Roman 4 the declarer cannot reasonably obtain possession of the check because the check was destroyed. Its whereabouts cannot be determined, or it is in the wrongful possession of an unknown person or a person that cannot be found or is not amenable to service or process. 4. Obligated bank means the issuer of a cashier's check or teller's check or the acceptor of a certified check. B. A claimant may assert a claim to the amount of a check by a communication to the obligated bank describing the check with reasonable certainty and requesting payment of the amount of the check If either claimant is the drawer or payee of a certified check or the remitter or payee of a cashier's check or teller's check. Roman 2. The communication contains or is accompanied by a declaration of loss of the claimant with respect to the check. Roman 3. The communication is received at a time and in a manner affording the bank a reasonable time to act on it before the check is paid. And Roman 4. The claimant provides reasonable identification if requested by the obligated bank. Delivery of a declaration of loss is a warranty of the truth of the statements made in the declaration. If a claim is asserted in compliance with this subsection, the following rules apply. 1. The claim becomes enforceable at the later of either time the claim is asserted